Well, hello. I am Priya Huskins, and welcome to the Stanford Rock Center for Corporate Governance's webinar on mandatory arbitration. There will be CLE links for this event in the chat. And before we get started, I'll also remind you that if you have questions as we go, the chat has been disabled, but at the bottom of your screen, there's a Q&A box, and we'll be able to see your questions there. So the topic is mandatory arbitration. We have the best possible panel to discuss this topic, and I'm going to ask them to introduce themselves. Joe, can you introduce yourself?
Yeah, hi, I'm Joe Grunfest. I am technically retired from the Stanford Law School faculty, but nobody's ever failed retirement as spectacularly as I.
Thanks, Joe. Jeff?
Good morning or good afternoon, depending upon whether you're on the East or West Coast. I'm Jeff Mahoney. I'm the General Counsel of the Council of Institutional Investors. CI is a nonprofit, nonpartisan association of U.S. public, corporate, and union benefit funds. We have combined assets under management, approximately $5.2 trillion. Our member funds include major long-term share owners with a duty to protect the retirement savings of millions of workers and their families, including public pension funds with more than 15 million participants. These are true and real Main Street investors through their pension funds. I want to thank you, Priya, Professor Grunfest, and the Rock Center for inviting me to participate on this panel. And I look forward to the discussion.
Thanks, Jeff. Glad to have you. And Greg?
Good morning. Greg Verrello from Bernstein, Ludowitz, Berger, and Grossman. I manage the Delaware office of the firm and come to the panel at Priya's invitation. I appreciate very much the opportunity to be here.
Thanks. And as mentioned, I'm Priya Huskins. I'm a senior vice president at Woodruff Sawyer, a Gallagher company. We are a commercial insurance brokerage, and I'm an expert in director and officer liability insurance. So it's no surprise that this is a deeply interesting question for me as well. To get started and to figure out where our audience is, we're going to do a few poll questions. And I think the first one is about to pop up. We wanted to know who's attending today's live webinar, and you can see your choices are officer or director of a public or private company, perhaps a company side advisor like an attorney or a banker or an auditor, a plaintiff's attorney, somebody in the insurance business, academia, or the press, perhaps also none of the above. You just like attending webinars. God bless. There's also a second question about if companies are allowed to choose mandatory arbitration, and just assume for this question, no state law impediment. Will class actions go away? Securities class actions go away over time? And your choices are within 10 years. It'll take more than 10 years, but it will go away, or no, it's not going away. Third quick question, are you in favor or against allowing companies to choose arbitration as the only path for their shareholders to resolve securities fraud allegations? Yes, leaning yes, but you want to know more. Another option is leaning no, but you'd like to know more. And then, of course, no, it's a terrible idea. And then they find, another question, do you anticipate that any companies will implement mandatory arbitration before the end of 2026? Answers are nope, maybe 1 to 3. You will see a clear trend towards arbitration, or loads of companies will do this. So let's go ahead and close the poll here shortly, and we can get some quick responses. All right. First one, you guys can see we have a nice spread of folks who are joining us today. Second one, a lot of nopes. Do not expect securities class actions to go away. So we're going to definitely talk about that. Are you in favor or against? 6% are in favor, 18% leaning yes, 48% leaning no. And 27% already think it's a terrible idea. And then number 4, do you anticipate companies will implement it? A very small percent for no, larger number for maybe, clear trend 38, and of course loads of company 12%. We're going to run those 2 poll questions at the end to see if anybody changed their mind. But you know what, let's get into it. And I'm going to start with you, Joe. This is not the first time arbitration has come up for securities fraud. Um, when has it come up before? What happened?
Well, first, a little bit of context. As a technical matter, what the SEC did is it basically said, we're not going to be following a position that the commission itself has never formally validated, but has always been the position of the staff. And what most people don't realize is how influential staff positions can be with regard to the ability to go public. And here we have to get a little bit wonky in the federal securities laws. Section 8A, in effect, says you can't go public. There's going to be a 20-day delay. And for practical reasons, you can't go public unless the SEC waives that 20-day delay. And that 20-day delay, waiving it, is called the process of acceleration. And acceleration is, in effect, a state of grace that the staff with delegated authority from the commission grants, and they're allowed to do it basically with consideration, and here I'm quoting from the statute, of the public interest and the protection of investors. And the staff position, with the commission's implicit blessing, although never a formal rulemaking or anything like that, is that an arbitration provision is contrary to the public interest and the protection of investors. That has changed. All right. Paul Atkins has come in and said, we're not going to take a position on that. All right. We're now, in effect, punting this issue to the states. And from the perspective of saying, okay, we have federal regulation and then we have state regulation, in effect, it's going to wind up being very similar to the Dobbs situation, where Delaware can say yes or no to arbitration, Texas, yes or no, Nevada, yes or no, and the commission will go, fine. Whatever you say is fine as long as you accurately disclose. Now, this is not a new question. The question formally first presented itself in 1990, all right, with the Philadelphia Savings and Loan. There, the company had an arbitration provision, and the staff refused to accelerate. And eventually, Philadelphia Savings and Loan caved because you're not going to go public. All right. And just as a practical matter, if you want to go public and the staff says you can't have this position, you're going to give the staff what it wants. The next major manifestation of this issue was in 2012. Carlyle filed its registration statement to go public. It initially had an arbitration provision. And it's my impression that what the staff did is it slow walked the proposal. And during the period when the staff slow walked, there was a revolution among the institutional investors. And they basically signaled to Carlyle, we really don't like it, and you want us to buy in the IPO. So without the staff doing anything other than slowing it down, Carlyle withdrew the provision, and then it actually wound up going public. Next major development, 2019, Johnson & Johnson, no action letter. And there, the bottom line is the chair, then Clayton, said that if there's going to be any policy to allow arbitration clauses, it would be adopted by the full commission. It wouldn't be by staff action. And here, as a practical matter, Atkins, he doesn't need full commission action. He would, if he put it to a commission vote, of course, it would be 3-1. All right. And that's pretty much where we are today.
And as we're talking about mandatory arbitration, Joe, does it have to be all or nothing? Just tease out a little bit of the nuance here.
Yeah, well, so to get now wonky in a different direction, this question about arbitration is really much more complicated. It's what academics would call a high-dimensional problem. Because when you come to me and say, okay, will there be arbitration? I go, what are you talking about? So first dimension, what kind of arbitration? Are we talking about preclusive arbitration where there will be no class action and every plaintiff has to arbitrate their claim on their own? Or is it non-preclusive arbitration in which you can have a class arbitrate a matter, but you then just have different rules of procedure and what have you? And if there are different rules of procedure that allow class arbitration, what are those rules? All right. And why would the corporation prefer those rules? And why might stockholders prefer or not prefer those rules to being in federal court? So when you come to me and say, gee, will there be arbitration? I go, what are you talking about? Arbitration isn't one thing. There's a huge spectrum of different forms of arbitration. Next dimension, which state are we talking about? You're talking about Delaware? Are you talking about Nevada? Are you talking about Texas? Are you talking about North Dakota? All right, because there can be tremendous variation, especially if there's going to legislation go in base. For who's totally different if remember Carlisle, or a company that's already publicly traded, but it's got a control stockholder, or a company that's already publicly traded, but there is no control holder, and control is basically, out. And then last, how does the market respond? All right, and all of that will be contingent on the other three. And if the market says, look, there's going to be a significant price penalty if you actually adopt this provision, then the probability of it going forward goes way down. Again, remember the situation with Carlisle, where the commission had to do nothing. And in effect was negative reaction from the investor community that caused the company to go, maybe not such a good idea.
So, but for clarity, the NC is not answering any of those questions. So to be really clear, all they're saying is, we're not taking a position.
Exactly. Stop. We're not saying anything. Texas, you decide what you want. California, you decide what you want. And we're good. We're good with all of that.
So Paul Atkins, in part of all of this writing, said, this part of many IPOs again. Joe, I'm going to sit with you for a second. So what is the problem arbitration is actually trying to solve?
I think there is a perception that not all complaints filed in federal court have equal merit. Some are higher quality, some are lower quality. And some of the work that you've done, Priya, suggests that motions to dismiss are granted in 50% of the cases.
Right.
And accepting those, there are other suggestions higher, some lower, what have you. There are executives that basically take the view that if half of the claims that are filed are just thrown out at the beginning, the law is too loose. All right, that there's too much betting, in a sense, going on. I get the case past this district court judge, and any business where it makes sense for the plaintiff's lawyers to file the 50% probability of getting motions to dismiss, it's too easy to file complaints. Now, there's a different perspective that says, the courts are being too strict when they eliminate half of the complaints. They know the complaints are better than that. And I'm just, without taking a position, I'm just trying to describe the opposite poles in the debate.
Yeah. And then very fair, right? Opposite poles of the debate. Just to give a little bit more context with numbers, and this data I'm sharing comes from Woodruff Sawyer's proprietary database where we track all of this securities class action litigation. If you look at payouts, so we have to now look at the companies that did not win their motions to dismiss. In 2024, we saw total payouts for settling securities class action lawsuits of $4.1 billion. And through the first half of 2025, we're at $1.1 billion. Now, I do want to give some context. There were some whoppers last year, some really big class actions that settled. So it's often a little bit more useful to look at median settlements. But I can tell you that the median settlement in 2024 was 16 million. That's about where we find ourselves if we look at the first half of 2025. And to help calibrate that over the last 10 years, the median settlement was $10 million. So it's real money.
Yeah, I'll just make one. The median is more relevant to the company. The mean is more relevant to the plaintiff's class action bar.
Well, and it may also be more relevant to insurance carriers. And so a lot of this is paid for, we know, by D&O insurance, which is something we're going to talk about. And notwithstanding that, for Woodruff Sawyer, 70% of clients actually saw a cost reduction in the first half of 2025. But I just want to spend a few more minutes with you, Joe, before I pull in Greg and Jeff. So, mandatory arbitration has been imposed by companies in consumer litigation and employment litigation. And in those arenas, we've seen a lot of pushback. So just remind us how this has worked out in the consumer and employment context.
More complicated than most people realize. And first, the experience in consumer and others is not going to be directly applicable here. So for example, in the consumer litigation, every consumer typically has a small claim, and it's not worth any consumer pushing forward. And if you have preclusive arbitration provisions, you in effect make the claim go away. That is not going to be the case with publicly traded securities. Typically, you have institutional investors, they have non-trivial positions, and if you've got a significant stock price decline that appears to be correlated with fraudulent activity, they'll have claims in the millions of dollars, and it'll be entirely rational for them to pursue the claims on an individual basis. And Jeff's members will wind up forming coalitions, and they'll hire the same law firm. There'll be all sorts of stuff that they could do to make the arbitration miserable, all right, for defendants and the individual defendants. So drawing a parallel between consumer arbitration and arbitration in the security space, it sort of immediately signals to me you don't understand how these worlds work, right? The nature of the plaintiffs is fundamentally different, and their resources to push forward would be fundamentally different. And I think that's a key point. And informed advisors on the defense side know that. All right. Now, the other thing is companies that adopt these provisions can engineer these provisions in a variety of different ways. They don't have to say it's AAA arbitration. All right, you can write customized arbitration provisions with your own arbitration rules and the whole bit. Yeah, you can go nuts on that. And it remains to be seen again, that's the first dimension of the problem. You say there's going to be arbitration, I kind of go, wait a minute. All right, it's a dog, but is it a Great Dane or a teacup poodle? There's a big difference. Both dogs.
Well, and to your point, if you look at consumer class action or employment arbitration, those are very mature industries when it comes to arbitration. The rules of the road are very well known. That would not be the case here. Greg, I'd love to pull you into this conversation. And you're an expert when it comes to Delaware law. How does this work in Delaware? Because the SEC was very clear, to Joe's point, they're leaving it to the states.
Yeah, so before I answer that question, let me just say that I think I agree with everything Joe just said. I agree with the 27% of your respondents who think this is a terrible idea. I agree with Joe, who thinks it's a dog. I couldn't agree more, Joe. It's a dog all the way around. And I very much think that this is a solution in search of a problem. I'm reminded of former Commissioner Jackson's speech. I think he made an article out of it called "Keeping Shareholders on the Beat." And the thesis of his remarks some years ago, and I think it's still on SEC.gov, unless Chairman Atkins has decided to purge comments he doesn't like or speeches he doesn't like. But what Commissioner Jackson said a number of years ago was, look, the SEC is budget controlled and constrained. The size of the markets have grown dramatically. The SEC budget hasn't nearly kept up with them. And we need private securities lawsuits to augment and supplement the work of the SEC. Look at, I hate to go back to it, but if you look at WorldCom, Enron, Tyco, the SEC got about $1.75 billion for those massive frauds. And the private securities litigation enforcement bar collected north of 19 billion for those same frauds. So very much I'm sort of scratching my head as to what the problem is. In terms of Delaware law, to answer your question, Bria, right now we've got on the books section 115C of the General Corporation Law of the state of Delaware. And as Chairman Atkins recognized in his speech just a week or two ago at the Weinberg Center, that particular provision of the general corporation law would prohibit making mandatory securities arbitration. So that would have to be changed if there was a desire to go down this road from the Delaware point of view.
And the process for changing it?
So the process for changing the corporation law requires legislation in Delaware in the General Assembly. The Constitution requires a 2/3 vote to change the general corporation law. And at least until relatively recently, there has been a well understood process that the legislature considers matters that come out of something called the Council of the Bar Association. The council is charged with drafting legislation. It's a group of Delaware corporate lawyers in particular. And over the last 60 to 70 years, just about every change to the corporation law has come out of the council and then laid before the legislature. That changed recently in earlier 2025. We had a really publicized fight about something called SB 21, which changed, among other things, Section 144 of the code. That piece of legislation did not come from the council. It came instead from outside the ordinary channels. But assuming we were to follow the ordinary channels, it would be the council that would make a proposal to the legislature to act, and then the governor to sign it.
Thank you, Greg. Joe, what about Texas or Nevada, who are much in the news these days as they attempt to take away Delaware's crown as the first state when it comes to incorporation? You are on mute.
I'm not licensed to practice law in Nevada or Texas, so I've consulted with people far more competent than I about these matters. And the consensus generally is, it might work under existing Nevada or Texas law, but everyone would be more comfortable if there was express legislative action in Nevada or Texas making clear that under our corporate regime, we would allow arbitration. So to the extent that people are looking to do this with the greatest degree of legal certainty, additional legislation in both those states would be a signal that people want to move in that direction. And that would also make the SEC's deference in those situations even more clear.
Look at us making laboratories of innovation on a state by state basis, right? I mean, that could actually happen and you could study it. Jeff, I want to pull you in to talk about the investor perspective, if I could. And and I hope this is not unfair, but I'd love for you to articulate the institutional investor argument, both in favor and against arbitration, because it's not just definitely without merit for consideration.
Thanks for the question, Priya. I'm going to start discussing what our membership approved policies are and go from there. As Professor Grunfest pointed out, the Carlisle IPO was a situation that got a lot of attention from our membership. And as a result, in 2012, our membership approved an amendment to our corporate governance policies. That amendment indicates that companies should not attempt to bar share owners from the courts through the introduction of forced arbitration clauses. And our policy was based on the view of our members that mandatory arbitration clauses in public company governing documents represent a potential threat to principles of sound corporate governance that balance the rights of share owners against the responsibility of corporate managers to run the business. The background and intent of that 2012 amendment states that relative to a trial, arbitration generally shortens the time required to resolve a dispute, enabling opposing sides to end uncertainty and move forward. It then goes on to state that, however, the increased speed comes with at least 5 potential trade-offs. And the first trade-off it references is the process for discovering evidence may be limited in comparison with a judicial proceeding. Second, the right to appeal may be rare. Third, arbitration awards may not be directly enforceable and may require judicial remedies to confirm the award. Fourth, arbitration may not allow similarly impacted parties to organize as a class. And the fifth mentioned in our basis for conclusions is that disputes that go to arbitration do not necessarily become part of the public record. Our background and intent, though, clarified that our policy does not object to voluntary arbitration, and specifically says voluntary arbitration, whether that's between two companies, between a company and a service provider, or between a company and an investor.
So it sounds like, as you listed those objections, it sounded like class action mechanism was a really important part of it. Is that fair?
That's fair.
Yeah, yeah. And just to dig a little bit into the question some more, as you consider this, and I don't want to ask you something that you'd feel uncomfortable with. What about the overall cost of a system that we do have today? I mean, it is true that we have more than 50% go away. It is true that your investors are paying for insurance, you're paying for defense attorneys, you're paying for settlements. So, any thought on efficiencies that are frankly lost, maybe perhaps by thinking about over enforcement by the, Greg, I'm going to use your phrase, plaintiffs enforcement bar.
Well, to Greg's point, we've cited Commissioner Jackson's speech as well, but we've also cited the comments of the longest serving SEC chair, Arthur Levitt, as well as the comments of former SEC chair Bill Donaldson on the same point, that they believe strongly that having access to the courts and class action lawsuits is a critical supplement to the SEC enforcement system, and that there is evidence that the amount of returns that investors obtain through those class actions, particularly for the large securities frauds, are much higher than what the SEC recovers for investors.
But couldn't that be changed by changing the SEC's recovery mechanism?
Sure, that's a possibility. It's not something we've heard proposals about, or so we haven't discussed it.
Yeah, and most companies aren't waving the flag for stronger government enforcement. That doesn't generally tend to be the way it goes, but just to make the economic point that exists. I guess, Jeff, the other thing is just Paul Atkins, his comment was making IPOs great again. I think the vibe was some of this class action threat is part of the reason companies stay private for longer. And you'd think institutional investors would want more public companies, but perhaps you disagree with that or disagree with the premise.
Well, there's a lot of different factors that go into why companies pursue an IPO, and there's been a number of studies around that. It could refer you to a recent study from the General Accounting Office. They interviewed me and others. I've also I've had several podcasts with professors that have studied this issue, and when you look at all the factors that come into play, generally, regulatory costs are not a significant factor that inhibits companies from IPOs.
Yeah, let me underscore and reiterate what Jeff said. If you think that these regulatory issues are what's suppressing IPOs, you don't understand what's happening in the capital markets.
And I'm just repeating what Paul Atkins said: make IPOs great again.
You see, but I'm not required to agree with Paul on everything. Not yet. not yet. All right. And so basically what's happened is the private capital markets are huge. They're relatively liquid. It's easy to synthesize a mechanism whereby a company achieves everything that it wants to achieve without ever going public. Easy example, Stripe. All right. Huge company, wonderful. Could it go public? Yes. Why would the founders take the company public? They don't need to. All right. Well, the employees need liquidity for their options. Great. Every year or so, they wind up, having a tender offer, and any employee that wants to sell the stock can sell the stock, get a price. All right. And people are generally comfortable that the price isn't a moonshot away from where it would be trading in the public market. Uh, so why go public? You don't need to go public. Back in the day, if you wanted to raise more than a certain amount of money, you had to go public because the private markets weren't that evolved. That's history.
Well, so Joe, let me stick with you for a second. So as we all know, there's an expressly created private right of action under the 33 Act. I don't think the same can be said for the 34 Act. So, first, do you agree with that? And if so, what's the big deal about allowing arbitration as an alternative?
Oh, well, here Greg is going to be antagonized. There's a clear express private right of action under Section 11 of the 33 Act. The private right of action under the 34 Act, although the Supreme Court has said its existence is beyond peradventure, is clearly something that has been manufactured by the courts and by the SEC. When Congress adopted Section 10B, the legislative history and text are absolutely clear. They never expected that there would be a private right of action. What they expected is this would be a way for the SEC to address open questions with regard to its own ability to sue. Never intended to allow individuals to sue. And then when the SEC in 1942 actually adopted 10b-5, we know why. Because because the pre-existing authority under 17A only allowed people to go after fraud in the sale of securities, and they ran across a joker up in Boston who was engaged in fraud in the purchase of securities. So they sort of said, gee, let's add purchase and sale rather than mere sale. And it mapped the statutory text of Section 17A, and there you go. And then the courts come along in 1947 and they invent a private right of action. Supreme Court then, Court versus Ash, 1970s, changes its view and says we're going to be narrower. And then in Stone Ridge, the court comes along and says, gee, if you've got an implied private right of action, in effect applying Sandoval in the context of the federal securities laws, it says you have to interpret it narrowly. Now, Greg and the plaintiffs bar go ballistic, perfectly understandable. If they're going to represent their clients' interests and rights, they don't want the narrowest possible interpretation. And a lot of what's going on now in litigation in this space is what kind of interpretation of a right of action that Congress has never defined and is, as a practical matter, a figment of the court's imagination, using an approach that would be entirely discredited if adopted ab initio today. How do we interpret this? Where does it come from? What kind of action constitutes an actionable fraud? That's the issue.
Well, and I bring it up because if your starting point is God in heaven said, "Lo, let there be private securities class actions under the 34 Act," you might feel differently than if you understand the history of the 34 Act. But we are here now, and
But what the commission's position basically is, it touches the 33 and 34 Act, because
understood.
you would say a Section 11 claim is arbitrable, just as a 10b-5 claim is arbitrable. So the distinction you're drawing is intellectually correct, but the SEC doesn't care.
Well, there we are. And very much we're here now. Like, it will really surprise me if this, suddenly some power higher than ours on this call decides that we should go back to how Congress actually wrote the act. We're here now, though other precedents have been overturned. But let's actually get practical and talk about boardroom dynamics. And for that, I'm going to go back to you, Jeff. I mean, in your view and understanding what the policy position is of your group, what should public company board members be thinking about as they consider this topic?
Well, Priya, I think it's fair to say that public company board members should be aware that adopting a forced arbitration clause will draw some negative attention, including from many CI members and other long-term institutional investors who support and have long supported our policy against forced arbitration. I would note that in 2020, I think Professor Grunfest mentioned this earlier, Intuit's proxy statement included a shareholder proposal to require mandatory arbitration for shareholder claims. That was filed by the Doris Bear 2012 Irrevocable Trust, whose trustee was Hal Scott, who's a professor, emeritus professor at Harvard Law, and a longtime opponent of shareholder class actions. That proposal received very little support. More specifically, over 97.6% of the shareholders voted against it. And I currently know of no reason why CII members and other long-term institutional investors would vote any differently if a mandatory arbitration proposal was put to a shareholder vote during the next proxy season.
Yeah, let me understand. I mean, if you want a fight with your stockholders, this is a good way to have one.
Well, and I'm going to turn to you, Greg, because there are different fights that you can have. There's the fight of your investors being upset with you. There's the fight of a fiduciary duty suit. So, Greg, opine a little bit on that. What should public company board members be thinking about as they consider this topic? And not asking you to necessarily opine against your own interests, but I would think that there is a way that a board could properly. Oh, that's a question. Could a board actually properly come to a conclusion? Is there a process where they could decide, yes, we do want to do it? May not be what Jeff wants, which is a different question, but talk a little bit about that process.
Sure. Let me start by saying a couple things. First of all, I'm not here on behalf of the plaintiffs' bar. No one elected me as spokesman for the entire plaintiffs'
Good
bar.
point.
I'm
Good
here
point.
on behalf of my firm. I'm here to talk as an individual from a particular perspective. Let me also add that my perspective is a little bit different than many plaintiffs' lawyers. I've been a plaintiff's lawyer for 6 years. For 36 years before that, I worked on the defense side at Delaware's leading defense firm, best firm by far, by the way, including all you who are on the phone who have come from other firms into Delaware market. Richard Slayton is and always has been the best firm for the defense side. In that capacity, I spent a lot of time in boardrooms, counseling boards on matters of Delaware law and fiduciary law in particular. And so my perspective is a little different than many. Look, I start from the point of view of understanding that from many corporate citizens' points of view, the idea of not having to participate in litigated securities law actions must seem like a really neat idea. But I think when we start thinking about it from the point of view of policy and particularly the board of directors, there's a lot more information that needs to go into the dynamic than simply, oh, great, we'll get rid of securities litigation. So this is one that I think really fits into, and I want to pick up on some points that the professor made earlier that were really insightful about the nature of arbitration. And this is a watch out for, what you ask for, because you might get it. So, right now we live in a world where, as you pointed out, Priya, more than 50% or roughly 50% of litigation that's filed in the class action area for securities gets dismissed. Well, there's a reason for that, right? And it's called the Private Securities Litigation Reform Act. And the PSLRA does a number of things that are really important in this area. They coordinates litigation. Effectively, a judge is picking one of potentially several competing litigations, several competing sets of attorneys to be the champion for the class. 2, it involves a stay of discovery at the outset of the case. 3, it involves a heightened pleading standard. Well, arbitration doesn't involve any of those things. The typical arbitration proceeding doesn't involve stays of discovery. It doesn't involve coordination. It doesn't involve coordination among different potential arbitrations. If you were to institute forced arbitration of securities matters, as Joe said earlier, I think quite rightly, there are many large investors in any particular security, giving indexing and other dynamics in the market, who hold very large stakes in our public companies. And if those investors were of the view that they had been defrauded by an issuer's statements or conduct, instead of having one class action to defend, you're likely to have dozens of arbitrations to defend. Those arbitrations, unlike matters committed to a federal life tenure judge with the potential of a circuit court and even a United States Supreme Court appeal, are likely to get decided privately by an individual arbitrator. Of course, it could be a panel of arbitrators if you provide that in your provision, but many cases an individual arbitrator. And, the rulings you would get in those arbitrations aren't necessarily going to be consistent. Let's just think about a potential securities class action fraud situation that was forced into arbitration. And let's say that gave rise to 10 different arbitrations. Well, that means 10 different sets of discovery if the arbitration rules involved allow discovery. That means 10 different sets of depositions of your senior executives. That means 10 different sets of defense lawyer fees. And that means potentially different answers by the 10 different arbitrators. There's no way to coordinate those 10 different arbitrations. One of the things that you dealt with in your research was the prevalence of dispositive motions being granted in the securities litigation class action. Well, guess what? I took a look this morning. I had a vague recollection of what the AAA commercial arbitration rules said, and I pulled them up and I took a look at them this morning. And Rule 34 of the commercial arbitration rules of the AAA, 34A, called dispositive motions, basically says the arbitrator will not allow dispositive motions in arbitration unless that arbitrator makes specific determinations that the moving party, and I'm quoting now, has shown that the motion is likely to succeed and to dispose of one or more narrow issues in the case. So you might not even have motions to dismiss in an arbitration proceeding. There's more. You're not bound by the rules of evidence in arbitrations. Again, the AAA commercial arbitration rules contemplate that the legal rules of evidence aren't necessary for the arbitrator to follow. So you're opening a door, should you go down this road, into lots of uncertainty, massive uncertainty, and the potential for a dynamic situation where you've got multiple problems to deal with from the general counsel's point of view rather than one. So if I'm talking to a board about this, or if I were talking to a board about this in my prior role, it would be watch out. There's a lot to be considered here.
So Greg, let me just push on one thing you just said. Couldn't we create arbitration provisions that say PLSRA basically applies? Stay on discovery and those kinds of, maybe that may not be the one, but do you see what I'm saying? Like, it's a blank slate. Why couldn't we have rules that address some of those issues?
Well, it's kind of strange. It's an unusual circumstance that we're leaving public securities litigation, right? And somehow we're importing that whole regime into arbitration. The whole idea of arbitration is supposed to be, and I understand reality doesn't always line up with this, but it's supposed to be speedy and efficient resolution. And, I think if you were to convene a panel of arbitrators and ask them how often they had granted stays or alternatively dispositive motions in arbitration, the answer is likely to be darn near zero. Not unheard of, but certainly very low incidence.
Joe, were you going to say
Let me
something?
expand on what Greg just said. Assuming everything Greg just said is absolutely accurate,
God, are we recording this? Are we recording?
Yeah,
No,
look,
we
I
are.
don't, I don't want to, I don't want to hurt your feelings, Greg, but we
Right.
actually have wound up agreeing on everything, and you're going to agree with what I'm about to say now too. Are you ready?
Oh,
What
boy.
is happening
That's
now?
how
What
you
is
feel.
happening?
I know.
What is happening?
The apocalypse is nigh. Um, if you were advising a board, and if you said, okay, what we want to do is we want to make this work, all right, my advice would be as follows. Have arbitration rules that adopt the federal rules of evidence, that adopt the rules of civil procedure, and that adopt all federal securities laws precedents, all right, that are relevant within the district, and adopt the PSLRA. The way you put your finger on the scale is by selecting the arbitrator. There is, in the federal courts, a tremendous amount of variance which arises simply by the identification of who the district court judge is going to be. When a company comes to me and says, Joe, we just got sued, all right, and we'd like your read on the situation. How exposed are we? The first question I ask, even before I say, what are the facts? Who's the judge? Who got assigned the case? Okay. Now I know the judge. Now I know where it's sitting. And now tell me what happened. In other words, the ability simply to select the arbitrator can be extraordinarily important, even if we wind up adopting all of the rules and all of the safeguards associated with federal process. I'll put it another way. The arbitrator you would pick, Greg, is not the arbitrator that the Chamber of Commerce would pick.
Jeff, anything you want to add on this whole what should public company board members think about when they think about do they want to adopt such provisions?
I think, as Professor Grunfest said, our policy mentions these 5 issues, and to the extent that all 5 of those issues could be resolved, then that'd be something our members would have to look at, and we would have to look at as to whether or not we revise our policy based on how arbitration would dramatically change under those circumstances.
Got it. Thank you. What about private companies, guys? I mean, it's a different boat. It's a different ball game. From time to time, I do find myself having to remind private companies that they are subject to the federal securities laws rules. Occasionally, that's a surprise. But is it different at all, Greg? I'll ask you first. Is it different if it's a private company?
Well, I think you've still got many of the dynamics we've talked about. I think that there's still a lack of transparency, a lack of accountability. You've got a situation where there could be circumstances where you had multiple arbitrations going on. Joe said earlier, when you start with arbitration and you say the word arbitration, you really haven't said a lot, because there are levels, as he called it, a multi-dimensional problem of complexity around that. I would say the same thing is true about private companies. When you say a private company, are we talking about a family-owned enterprise that's an LLC formed under Delaware or Nevada law with 5 members? Or are we talking about a unicorn? Are we talking about SpaceX? What are we talking about? There are many different answers given the nature of the private company you're talking about.
Joe, what are your thoughts? And is there a suitability question? I mean, I think that's what Greg is elucidating.
Easy way, and easy, there are provisions in the law that are called anti-reliance clauses, that used to be called, big boy provisions, but
Yeah.
don't call them that anymore. If parties to a transaction are sufficiently represented by sufficiently sophisticated counsel, you can waive reliance, all right, on, statements that are otherwise pure fraud. It would seem to follow a fortiori that if you can waive reliance, you can waive the right to litigate about a situation, and where to litigate about a situation when you're not waiving reliance and you're saying there is a fraud. So it's a little bit like it's a lesser included proposition, which means that in many situations, if you have a privately held company, I would know how to litigate in Delaware law to say this is just fine. So I'll just take an example. Yes, there are a million different variations. But if you have an early stage typical Silicon Valley startup where you've got, I'll just make up, Sequoia Benchmark and Andreessen Horowitz throwing 100 million into, some operation. And the organic documents basically say if there's ever a dispute, we're going to wind up arbitrating it, and here are the rules under which we're going to arbitrate. I would predict that I could get a Delaware court to say, yeah, that's fine, that's enforceable.
Yeah.
Right?
Uh,
Greg,
I think
are we still in harmony?
No predictions on what Delaware courts do. Not for
um,
me.
I mean, one thing I'll say is it's my great hope that we have some large, highly valued private companies decide to give this due consideration. We benefit, right, when we can see a little bit of innovation and experimentation in corporate governance world, because then we get to study it. And see what happens. But most directors and officers, if they're thoughtful, they don't necessarily want to experiment on their own dime, their own personal liability, which gets us to my favorite topic, yes, D&O insurance. And so I am very curious about what this panel might be thinking on that topic. And I am going to start with Joe. You and I have spent a lot of time thinking about multi-front wars, thinking about, can we, for example, make sure 33 Act matters stay in federal courts and not all the state courts of the land. So, Greg, I'm going to start with you perhaps on this. What would you be telling insurance carriers? How do you think about this exposure? You've touched on it, but maybe say a little more.
Yeah. So look, I would call this the Full Employment for D&O Professionals Act.
God bless.
I think this is an insurance boondoggle or nightmare, depending upon your perspective. Um, the first thing I would say is all of the algorithms and data you use to price risk in the public securities litigation just went out the window. In a scenario where you have no ability to predict what an individual private arbitrator is going to do, or 10 individual private arbitrators are going to do in forced securities litigation. I'm sorry, forced securities arbitration. Um, there's just no way to gauge what's going to happen. In addition, Priya, I think we know and or can estimate with some degree of objective certainty that overall, the typical SEC litigation settlement winds up being X% of the loss. I don't know what that is in any particular year, but I understand insurance companies look at the percentage loss as opposed to the claims, and can tell you with some degree of certainty, if you're going to have a settlement, it's likely to be between X and Y% of the claim. That just went out the window in arbitration, right? Because first, whatever the data is, you're now talking to individual large investors who have been forced into this arbitration. And you can talk all day long about how the last 100 settlements on the public front have averaged 6 cents, 8 cents, 10 cents on the dollar, whatever the numbers are. I don't have them at my fingertips. And the answer from the large institutional holder is going to be, yeah, that's very nice. That's all very interesting. But now I'm in arbitration. It's just me. And I've got, a reasonable arbitrator. And I know what my case is about. And you know what? I've got contingent counsel. We're going to the mat on this. And so the answer is going to be 0 or 100%. And if you're going to be talking about a settlement, my prediction, I don't make predictions about Delaware courts, but I will about this matter in arbitration. My prediction is that your settlements are going to tend much higher than the settlements you get in PLSRA cases. So bottom line, I think that there are real possibilities here that you're going to have a terrible time trying to figure out what the risk is in this this parallel universe called arbitration. You're not going to get lots of experience. Anyway,
I'll just make that. I think there's a lot of merit to what Greg just said. with the observation that
Mark this data.
that Greg doesn't publicly make predictions about what the Delaware courts will do, but private plaintiffs always make predictions before they decide whether to take cases, right, and whether to prosecute cases. It's rational business, right? It's also rational not publicly to say what those predictions are.
Yeah. So in case people are wondering, public company D&O insurance today already contemplates, at least in the form, the coverage of arbitration. However, I think it is fair to say that informed D&O insurance underwriters, and they do tend to be a very informed set of folk, they were also extremely aware that that coverage grant exists, and securities class actions or securities fraud cases brought by private plaintiffs were not things that went into arbitration. So if nothing else, you could potentially see a shift that will be underwritten towards, and that can be very interesting. After all, we can all make all the predictions we want. D&O insurance underwriters actually put capital behind those predictions. And so that may be an interesting evolution for that next IPO company that decides to do this. There have been some insurance commentators that have opined that this is the end of D&O insurance. That is silly on its face, because of course D&O insurance covers a lot of things, and none of this is about fiduciary duty suits or the SEC coming after you, DOJ defense. Obviously, you don't use insurance for settlements, bankruptcy. There are many places where I'm not worried about the industry is what I'm saying here.
I'll just add very briefly that whoever made that statement basically proves you don't need artificial intelligence to hallucinate. People can do it on their own.
Hilarious, hilarious. We are going to, in the few minutes we have, launch those 2 poll questions again. So here we go. After hearing this discussion, are you in favor or against allowing companies to choose arbitration as their only path for shareholders to resolve securities fraud allegations? And number 2, do you anticipate any companies will implement mandatory arbitration before the end of 2026? Right? We have discussed that when you say arbitration, it's a big word that might contain multitudes. But directionally, we're trying to get some answers to these questions. And I am going to look and see if we have, if the poll can go ahead and close, and we can see if the needle changed. Always very interesting. All right, the first one, yes, companies should have this option, went from 6% to 24%. No, this is a terrible idea, however, went from 27% to 49%. So the movement was all in the middle. I feel like people solidified their views. That's not a bad thing. And number 2, do you anticipate anybody's going to do this? The nopes went up from 3% to 16%. The loads of companies will do this went down from 12% to 6%, with the other 2 categories staying actually rather stable. So thank you, friends, for participating in the poll. And we're at time. So what we did today with Jeff and Greg and Joe was explore some of this early landscape when it comes to the concept of arbitration for securities claims, something that's now at least somewhat available insofar as the SEC is not going to block registration statements on that basis. My thanks to the Stanford Rock Center for Corporate Governance for hosting this event, and to Jeff, Joe, and Greg for your participation today. Thank you so much.
Thank you.
Thank you.
Take care.